Hello everyone, I'm Dwight Mitchell, the founder of Family Preservation Foundation. Welcome to our Child Protection Series Pro Se Help Kit video series. Today's title session is on civil maltreatment findings. This is if CHIP finds you or your child in need of protection or services. I hope you enjoy the content and it allows you to better understand your rights and options while you're involved with CPS, and that it allows you to be more successful. For those of you who are looking at this session for the first time or don't know who I am, after a 22-month battle, I successfully defeated Dakota County Social Services in Minnesota and had my children returned to me. Although filled with anguish, it was an educational experience to say the least, and I will be passing on the benefit of my knowledge and lessons learned while cross-referencing the Minnesota state statutes, case law, and other things which are readily available on the internet or Google Scholar. I'm going to tell you how to go about getting it. This video series comes with a companion PDF, so you should be following along with the PDF as I go through this series. I have to put in my video disclaimer that I have to put in at the beginning of every single video. I need to advise you that I am not an attorney. I recommend you to obtain your own attorney if possible. I'm not providing legal advice. This video series is for educational purposes only. It's very important that you understand that you are working for yourself. I don't want you to be misguided. Look at my video session on working with your attorney so that you won't be misguided. I hope this assists you, as you move forward and with your case at CPS. Part of the education is to try and make people understand what is properly available to them. And I'm going to go over everything from the beginning, the middle, and the end, including the trial. There's going to be a lot of videos that go along with this. And hopefully it'll help you in defense against CPS. This will be hard work, make no bones about it. You're going to have to do a lot of reading. There's going to be some Minnesota templates for you. But anything I provide is for you. You're creating this for yourself. The word pro se in and of itself means for yourself. You're not allowed to go into court and say, oh, well, I got this from X, Y, and Z, or, Billy Bob told me to do this, or, Johnny Bob Thornton said to do that. No. This is you making decisions for yourself. All I am doing is educating you, and I'm showing you where to go to get the information you need to make informed decisions, and how not to let people take advantage of you and tell you things that are not accurate. So the part of the process that happens, and especially if you are, I don't know if you're in the middle of a proceeding now or halfway through or at the very beginning, but the overview of the process and the investigation of maltreatment starts by someone making a phone call. And the county screens in thousands of calls in and out a day. So I tell every single parent, if an investigator shows up at your door, take it very seriously, because 90% of the time, that investigator already believes you're guilty. Otherwise, they wouldn't be at your door, truthfully. They're there to collect evidence. So look at my video series on your rights, knowing your rights, because that's something else that's very important. So when the county investigates the reports of maltreatment of a child, they or a licensed care facility, they have to follow certain statutes. So when you're talking about applying maltreatment to minors, that's Minnesota statute 626.556. It's a very, very broad statute, all-encompassing. Sometimes I think it's a little bit too broad, but here again, that's my own opinion. So it has the capacity to cause huge problems, for those deemed to have committed maltreatment. And when I say, it can ruin your life, ruin your licensing, take your kids away. You can't get certain jobs. And so there's this huge statute that really is so vague and liberal that in reality, when I say they, Child Protection Services has this great big grand playing field to do pretty much whatever they want to do. So a civil determination also does not preclude criminal charges. So say you spank your child and they say, okay, well, we think that that's malicious punishment of a child. And then they could turn around and prosecute you criminally for the same thing also. So that's why I said it has these huge implications that you should be aware of. One thing you should, take away from everything I'm saying right now is that the burden is on the county. The preponderance of evidence is the county has to submit evidence to the court that you are in fact, neglecting or abusing your child. You don't have to prove you're not doing it. They have to prove you are. They may have a finding that the child is not in need of protection, but, that maltreatment still occurred, and that's all discretion. It's based on what the social worker thinks. So whether the social worker likes you or not, or whether they pretend to like you or pretend to be your buddy is irrelevant, If there's a determination by the social worker, because the social worker actually makes this determination, please, please, please make sure you appeal it. So many people are not aware that there's these two separate determinations. So there's a maltreatment determination by the social worker, which goes to the state, and then there's a civil proceeding, and the two are separate. And then on top of that, there could likely be a criminal proceeding also. So there's three determinations that you should be aware of throughout this whole process if CPS comes knocking at your door. The forms of maltreatment can be 1, physical abuse, 2, neglect, and that's a nebulous term when it comes to the social workers. We'll get more into that later. 3, sexual abuse, 4, mental injury. That's mental abuse. Now, while all of these may sound rather straightforward, the language of the state statute leads some to illogical and or inappropriate results. To say inappropriate, I'll give you an example. 84% of all the removals are for non-physical harm, based solely on a social worker's discretion. I'll repeat that. 84% of the removals are for non-physical harm, and it's based purely on the social worker's discretion. They could be having a bad day and they don't like you, and there's nothing you can do about it. And in my humble opinion, that happens a lot. So if they're removing children when there's no harm, to me that's a violation of your constitutional rights. And they need to prove this other neglect, and they can't prove that neglect unless you give it to them. They can make the allegations, but when they come to trial in 60 days, they need to have hard facts and evidence that's undisputed that you neglected your child. And 90% of the time that doesn't happen. What they do is they get you to confess, or you to admit to services, or you to say, I'm going to do the services. So we'll discuss that later on when I talk about the admit, deny, and things of that nature. But, don't help them do their job. Never. So the first is physical abuse. So we'll talk about physical abuse. And that's broad. And when I say broad, in Minnesota, broad goes to, a bruise in Minnesota is considered physical abuse. Temporary retting, that goes away. Some people you can push on their skin and it'll turn red, and it'll stay red for maybe 20 or 30 minutes, and then it'll finally just fade away. Well, if they see that, because some people's skin are very sensitive, they can consider that abuse. I had one parent who had to go have her doctor write up a letter because she was afraid that someone would say she was abusing her kid because her kid bruised so easily. And the doctor said, no, the child has this condition, it's very sensitive skin, and there's nothing wrong, with the child, and the child is not being abused. So that's something to keep in mind. So physical abuse means any physical injury, mental injury, or threat of injury. Get that threat. If you say, I'm going to give you a spanking, but you don't, that threat is considered physical abuse. It's weird. That's the way the Minnesota state statutes are written. So that's inflicted by any person other than any person who's responsible for a child. So unless there's a history of an injury or, it's in the doctor's records that there's injury, they can consider that, physical abuse. Now, the definition of an accident is very narrow. And when they say an accident, you could be sitting on your couch, and I can't tell you how many kids have rolled off the couch. They're going to say, well, the kid shouldn't have been on the couch. So when they say an accident means sudden, not reasonably foreseeable, unexpected. That's like an accident. So, you're sitting, you're standing on the curve, and a car jumps the curve and hits you. They consider that an accident. Your child runs into the street and gets hit by a car. They don't consider that an accident. They say you should have been holding your child's hand. Your child falls off the couch. They don't consider that an accident. You shouldn't have had your child on the couch. So I'm just trying to tell you the difference of what they call an accident, what you might perceive as an accident. Meaning anything that you could have prevented with thought, care, and diligence, they don't consider an accident. So keep that in mind. While the state statute says abuse does not include reasonable and moderate physical discipline of a child administered by a parent or legal guardian, which does not result in an injury, well, that's a fallacy. That's a misnomer, because if you look in their statutes or if you talk to somebody, a bruise is considered an injury. So basically, anything that you do that leaves a mark is considered an injury. So that's what they define as physical abuse. And then they have what they call not reasonable. So then they try and come back and say, okay, well, let's try and define this, to say what we consider not reasonable discipline. But while they put this definition in there to say what's not reasonable, they still left in the state statute that says anything that does not result in a permanent injury, which is a bruise. So they put in, what they consider reasonable, but left in this loophole for them. So, they're playing this double standard. So they say, not reasonable. And this is, to me, I think it's not reasonable anyway. Throwing, kicking, burning, biting, or cutting a child is not reasonable. Of course it's not reasonable. Striking a child with a closed fist. Shaking a child under the age of 3. Striking or other action that result in a non-accidental injury if the child is under 18 months of old. Well, you shouldn't be striking a child under 18 months of old anyway. Yeah, so some of these things are real common sense, but they got to put them in there because people will come back and say, well, that's reasonable. No, that's not reasonable. Cutting your child is not reasonable. So interference with a child's breathing, choking a child, that's not reasonable. Threatening a child with a weapon, that's not reasonable, and that's defined in subsection 609.02, subdivision 6, state statute. That's like threatening a human being with a weapon. You can't threaten anybody with a weapon, a knife, a gun, a bat. That's against the law. So when people think that that's reasonable, I'm not quite sure where that comes from. Striking a child in the face or the head. You can't strike a child in the face or the head. You can't give a child poison, alcohol, or anything that's dangerous or harmful. That's not considered reasonable, and that's common sense. So something else is like unreasonable confinement. You can't chain your child in a basement. You can't lock your child in a padlocked room. Some of these things are further elaborated in section 609-379, but to be specific, so you're aware and you can't say that, oh, I didn't know. You can't tie your child up. You can't put him in a cage. You can't chain him up. These things are considered unreasonable. You can't sell drugs to a child in a school zone. That's considered unreasonable also. You can't discipline your child in a school zone or a facility. But guess what? The teacher can. So it's against the law for you to spank your child in school, but it's not against the law for the teacher to spank your child in school. Minnesota State statute. Go figure it out. I mean, that's something we're fighting in our federal civil rights lawsuit that's before the appellate court. That's, it's unconstitutional. It's not equal. It's not fair. A total stranger can spank my child, but I can't spank my child. That doesn't make any sense. So that's one of the things that we're fighting. It's an unequal standard in Minnesota. So any of these things that happen, guys, just be aware. CPS is going to come after you and tell you that your child's in need of protection or services. So, let me move on. I was trying to think if there's any other issues that I should really cover under abuse, but in reality, a lot of it is common sense. It's the non-common sense things that drives me nuts, and then they wonder why our kids are like out of control right now, like why the kids don't respect the teachers, why the kids curse the teachers. I'm like, the kids have no fear. They're like, what are you going to do? You can't do anything. But I digress. I'm sorry. Let me get back to this this session. Keep my opinions to myself. Neglect is the next one. Neglect is by far the biggest issue in Minnesota. 84% of all the CPS cases in Minnesota are neglect. And neglect is this huge area that needs to be addressed somehow. And it's like, it's so broad. It's just unbelievable. So neglect in Minnesota means the failure by a person responsible for a child's care to supply a child with the necessary food, clothing, shelter, health, medical, or any other care for the child's physical or mental well-being when reasonably able to do so. The thing about this is that CPS takes that whole sentence and puts that on your petition. And they don't specifically state, which one. They'll say all of the above, So we'll get into that later on, too. 2 is the failure to protect a child from conditions or actions that seriously endanger the child. So I'll give you a classic example because this happens a lot. You're in a relationship and the man is abusive. He's physically abusive to you. And then finally, he lashes out and hits your child. Well, they're going to find you in neglect because you knew that man was abusive and you didn't leave and get that child out of harm's way. And you can say, but I didn't do it, Now, the only way you can escape neglect is if it's you as a parent, as a mother, is if this is the first time it ever happened, you weren't home, and there's no prior examples or nothing on the record, no police reports or anything of that nature, that anything was nonviolent. So if you're out, say you're out at the store, food shopping, and the baby gets hurt or the child gets hurt with your husband or your caretaker, that's not neglect against you. You weren't there. You couldn't have reasonably foreseen what would have happened, or you could have stopped it. So, but failure to provide, the necessary supervision or child care arrangements for your child, and your child gets hurt, that's considered neglect. Failure to ensure that your child is educated or goes to school, that's considered neglect also. So, those are some of the things to keep in mind because 84% of the children taken are from neglect. Neglect doesn't mean, say you're acting in good faith and something happens, or say you're trying to stop your child or trying to save your child or trying to do something and the child gets hurt, that's not considered neglect, because you were physically, you were in good faith trying to protect or trying to stop something. Neglect means you're not, you didn't use your due diligence, or you're not trying to stop or do something. Prenatal exposure, big topic, people. If you're drinking, doing drugs, smoking, things of that nature while you're pregnant, that's neglect. And I'm here to tell you, that's a hard one to fight right now. There's a lot of law going back and forth, but if you're doing drugs and you're pregnant, they consider that neglect. Medical neglect is another one. Say your child is sick and you're not taking your child to the hospital or to the doctor. That's considered neglect also, because the child is sick, the child should be going to the doctor, and you're not following up. And if the doctor says come back in 30 days and you don't go back in 30 days and it's a life-threatening condition, that's considered neglect. So be aware of that. Even if you don't have the money, that's considered neglect. If you're an alcoholic or use a controlled substance, and you're home and you're knocked out and your child is sitting there and your child gets hurt and you're passed out, drunk or on drugs, that's considered neglect also. Emotional harm is a little bit more difficult to prove, but that's mental abuse. If you're mentally abusing the child, emotionally scaring the child, not being nurturing and loving, and the child is afraid of you every time you walk up to the child is like, well, they consider that neglect too, and that you mentally, have scarred. You might not have never physically touched that child, but you've messed with that child's head to such an extent that the child is terrified of you. So they consider that neglect. Neglect does not require an injury, which is why so many children are taken from neglect. Your kid gets out of the house, out of the car, starts walking into the street. They're not hurt, but a neighbor calls and sees that's still considered neglect. Neighbors have called, the kids are riding the bicycle up and down the street with a helmet on. Neighbors have called CPS. The child is out unsupervised. I know of it happening firsthand. And the mother was sitting on the porch with the baby, watching the daughter ride back and forth. The neighbor didn't see the mother and called, and CPS got involved. The mother's like, I was sitting on the porch watching my child. Like, who called? So that's being a poor neighbor, because if anything, the neighbor should have came next door, or at least came outside before they called CPS. So exposing to a child to something might just be enough. Bleach or pneumonia. We all have the safety locks on our doors, and say but one by accident you didn't put the safety lock back and the child gets into bleach or something, that's considered neglect. So these determinations of maltreatment are something that's done by DHS, Department of Health and Human Services, and so it's only applies to those individuals in the state of Minnesota. Each state has its own criteria and sets of guidelines. So in your state, go look up what's considered neglect in your state, what's physical maltreatment, what's malicious punishment of a child. Make sure you're totally familiar with everything so you know how to present a defense moving forward. Here's what they have to prove, and so then you have to ensure that you have a defense, or there's no way they can prove that against you. DHS conducts about 200,000 of these assessments each year, across the United States. If serious maltreatment or reoccurring maltreatment occurs, individuals can be disqualified from jobs, direct contact with the individuals, working in a licensed facility like daycare or hospital or something of that nature. And a disqualification lasts for 7 years. So there's serious ramifications to be having been found maltreatment. Serious maltreatment, that's a whole other topic. So if we're talking about serious maltreatment, we're talking about sexual abuse, maltreatment that results in death, neglect resulting in serious injuries. Say you don't take your kid to the hospital and he has a heart attack, or he has a cut and you don't treat it and he gets a serious infection. Anything that requires the care of a physician and you don't follow through with that, those are forms of serious neglect. Just so we're aware, the care of a physician is a person responsible for treating the child, or if the physician gives you an order, or if a physician gives you like medication or something of that nature and you don't follow it, then that's considered neglect on your part also. So the diagnosis for testing, assessing, observations, treating the child, all of those, if you don't follow them, are considered serious neglect for a minor child. So if the doctor prescribes a prescription and they said the child has to take all of the prescription and you don't administer that prescription to the child, that's considered serious neglect. So abuse resulting in serious injuries, broken bones, bites, laceration, fractures, dislocation, evidence of internal injury, third-degree burns, or even burns which are not third-degree, any burns, period, but third-degrees are very serious burns. Drowning, heat exhaustion, leaving the kids in the car. Those are forms of serious neglect, and they generally come along with criminal charges also at the same time. So it's very broad. There's huge discretion on the social worker grounds. So if they're coming at you with a neglect charge, you have to get them to be very specific. Make sure it's written down, and make sure you're able to ascertain what you need to do as a defense, by talking to your attorney. Never admit to it. Always fight. Always put up your defense. But you need to know what needs to happen in that regard. Recurring maltreatment. Recurring maltreatment is as the name states, maltreatment that happens again and again and again. If neglect happens, once in a day or something of that nature, that's recurring. If you expose the child, that's not recurring. If it just happens once, it's not recurring. But if you expose a child to the same hazard, like 2 or 3 times a week or 2 or 3 times a month, that's called recurring neglect. If you're in a house where you're surrounded by drug paraphernalia, or people are coming in, doing drugs all the time, that's exposure to recurring neglect. So it doesn't have to include any injury. It can also be injury. Recurring neglect, repeatedly chaining your child in the basement is recurring neglect. But repeatedly exposing your child to drugs or chemicals is also recurring neglect. Again, very broad. It can be something like, dirty diapers. Every time I go to visit, that person's house, there's dirty diapers in the trash. And I kid you not, I use that example because it has been used. I've seen it on petitions. Dirty diapers in the trash. I'm like, where am I supposed to put the dirty diapers? They go in the trash. But that's what social workers will say. Dirty, stinky diapers in the garbage. And, I don't have a diaper genie. I use the garbage. That's my way, of disposing of diapers. So just something you should be aware of. So if there's a finding of maltreatment by the social worker now, it can affect your employment. If you work as a volunteer in certain facilities, or if you're licensed by DHS to do anything in the state of Minnesota, it automatically affects that. You can no longer do that job. Quite a vast number of jobs in these areas includes like laundry workers at nursing homes, janitors at hospital, mental health homes, nursing, child care, foster care. Any of those jobs, if you're found to have, maltreated a child, or there's been a determination of maltreatment, you can't do that anymore. Say in licensing, if you hold a license at an adult or a foster care facility, if you have a nursing license or anything of that nature, here again, you can lose your license. So depending on the case, you should appeal all your determinations. You're entitled to a fair hearing by an administrative law judge at DHS. The state statute for that is 245C.27. Make sure you look at that. Make sure that you appeal and contest every determination finding. Just don't accept it. You don't have to accept it. Bring in your proof, to the administrative office and have your hearing. If you don't appeal when the county makes the original decision, you can't appeal in the future. I think you have either 20 or 30 days to appeal, and you'll get a letter from the social worker saying, we found that maltreatment didn't occur. And believe it or not, I think they send that letter out to everybody. I don't know. I shouldn't misspeak, but I know of, everybody I've met has gotten that letter. Even, and what's really ironic about that letter, even if you're found not guilty and your child is found, say you got your trial in 60 days and it says, no, your child is not in need of protection or services, that maltreatment finding still stays on your record by the social worker. So if you don't appeal it, that stays on your record. And even if you're found not guilty, that maltreatment still stays in your record. So everyone should definitely appeal that finding, no matter what. I'm not talking about the civil case. I'm talking about that social worker's determination of maltreatment that comes generally 2 to 3 weeks after they open a case. So, please keep that in mind. So any individual who is disqualified from like direct contact positions may ask DHS to do a set aside the disqualifications. It's a paper hearing, a no appeal hearing. So it may allow an individual to work at a specific job. So, try and get that maltreatment voided or set aside. The timeline is averages about 2 months. It's hard to win in the appeals court. There's a lot of discretion by DHS, but even still, you got to appeal. If you don't appeal and you don't get it set aside, your employer may not, allow you to work. You may have to wait like 2 months or so before you go back to work, before they reconsider you. And that's, you got to eat, you got to take care of your family. So that's something that you need to consider also. So you may be required to tell your employer if you get this maltreatment finding and what to do. It may be reclassified under the Data Privacy Act so that nobody can come and find out about this appealing or hearing. So, please keep that in mind when you come to looking at maltreatment findings, set-asides, and appealing. I can't tell you how many people I know that were found not in need of protection or services, and then you turn around and you look up and they still have this determination and they can't get jobs. Then they end up having to move out of Minnesota because they worked in like a nursing home, they were a nurse or child care, and the social worker will not tell you. They'll send you a letter that tells you to appeal, but they don't tell you the ramifications. They put it in there, but they really don't tell you how significant it is. So I'm going to end on that note in closing this session of maltreatment, what's considered maltreatment and the findings, and what you have to do to prove your innocence, and appeal at all time. I hope you got something out of this session, and I hope it benefits you. Stay tuned, look at some of our other educational topics, and I look forward to seeing you again next time. You have a great day, and thank you for listening. Bye now.